Hi, we're Group 2, and today we're going to be presenting Case 2, which is the case of the Singh family against Progressive Builders. The Singh family was contacted by a sales representative for Progressive Builders named Helmet, and they agreed during the invitation to treat to have a house constructed that was a Mark IV model home in exchange for $575,000, and the date of completion was agreed to be no later than February 28th. They paid a $50,000 deposit, and construction began on the house. The Singh family did not read the contract that was written up after the invitation to treat, and in that there were provisions written for the correct model, which is the Mark IV, and the price, which is $575,000, but said that the date of completion was instead tentative and was only required to have confirmation of construction 60 days prior to the actual completion of the project. The significance of the change made by Helmet to the conditions between what was agreed to during the invitation to treat and what was in the final contract is important because the Singh family had rental accommodations that expired before February 28th, and so if the house was completed late, they would have nowhere to live. The Singhs were not informed of these changes to the terms, and they were written in the fine print, and the final terms did not accurately reflect the agreement reached during the invitation to treat as a result. Helmet, the salesperson that originally sold them the house, later came back to the Singh family and promised them on-time delivery by February 28th in exchange for an additional $27,000 payable to him directly instead of to Progressive Builders. The house constructed was not completed by February 28th, despite the Singh family paying the $27,000 that Helmet requested. The house completed was in fact a Model 3 home and not a Model 4 home, which does not include a den, among a few other features. And Helmet fled with the money that was paid to him by the Singhs, and apparently during the time when he requested it, according to the Progressive Building Company, was no longer in their employ at that time. This case has a lot of moving parts, and there are a lot of legal principles that we're going to need to draw on in order to analyze this case, and that includes fraudulent misrepresentation, largely because of Helmet, contract law and what constitutes a valid contract, agency laws and the use of proper authority, and what constitutes proper performance in contract law. In terms of just the bluntest question, which is the deal that the Singhs have entered legally binding? Yes. They are obligated by the terms of the agreement, but not all of the terms, necessarily. A lot of it is a little more complicated than that. In order to establish if the contract that they entered into was legally binding, we need to establish the 5 core elements of a legally binding contract. That includes consensus between the parties, consideration for all of the parties that are intended to benefit from the terms of the contract, capacity to bargain, legality of the contract, and intention to enter it. As a result, the July contract is legally binding because it includes all of these 5 factors, and both of the parties agreed to it. The October contract with Helmet and the $27,000, on the other hand, is not, because it doesn't include consideration for the Singh family. They do not get any benefit past what they were initially promised during the invitation to treat, and what they were given the impression the contract they were agreeing to was presenting. The contract that the Singh family and Progressive Builders entered into in July is a legally binding document because it fulfills all the expectations of a contract. And seeing as Progressive Builders have already now built the Mark III house and the contract is valid, there are binding obligations on the Singhs unless if all parties involved in the contract agree to leave it. The $27,000 agreement with Helmet signed in October, on the other hand, is not legally binding because, A, as previously discussed, there was no consideration made for the Singh family because they got nothing out of the contract that they weren't already supposed to get from the contract that they had signed before. The agreement was made in Alberta, while not in writing, and dealt with real estate, and according to the statute of frauds, all documentation regarding real estate in Alberta has to be in written format for it to be valid or under seal. An obvious question to be asking here if you were the Singh family is, why is this contract considered completed at all when it's the wrong house. They specifically requested the Mark IV. The contract stated that it was going to be a Mark IV, and the house that was constructed was not that. The simplest way to put it is it constitutes substantial performance because the terms of the contract, while not completely met, have been substantially met, and the Singh family will gain a substantial benefit even if they do not get the Mark IV house specifically. And so despite the deliverable presented by the construction company being wrong in a pretty major way, the Singh family still gets significant benefit from it. And since the substantial performance expectations for a contract like this would likely be seen as met by a court, the binding obligations on the Singhs and the construction company still exist. The February 28th completion date was a condition of the contract. It was a condition that before Helmut changed the terms and hid the warranty in the fine print existed, and so it was not added post-signing. It was not a suggestion, it was a condition from the very beginning. And it is unlikely that the Singhs would have entered the contract if they had known that it was not going to be treated as a condition. And conditions are terms of the contract that the whole of the contract relies on the fulfillment of. The final contract included a warranty provision that benefited progressive builders by saying that they did not have to complete the house by the agreed upon date as previously discussed, but rather that they could have it done at any date as long as they notified the Singh family 60 days prior to its completion. The warranty detailed in the contract is not valid. If a company wants to use a warranty like this to limit its liability, that is fine and legal, but it has to bring the terms of the warranty to the attention of the limited party. They cannot hide it in the fine print of the contract and then later try to enforce the terms when they were never discussed. If a court were to say, despite it being hidden and subversive and all of these things, that it is still a warranty that is applicable to the case and that it is valid, there would then be a very strong case for misrepresentation from Helmut never having discussed the terms and for hiding it in the fine print. One mistake that the Singh family could make in this situation, which as you've probably seen they have a very advantageous position in this case, is to simply say, this house isn't what we wanted, the contract is not what we were expecting, we're walking, and this would be a huge detriment to them because of anticipatory breach of contract. By saying that they're not going to fulfill their expectations of specific performance as detailed by the contract, they're effectively implying the repudiation of the contract, but that does not free them from the terms of the contract because it is still binding. By walking away from the contract and committing an anticipatory breach, the Singh family would be vulnerable to legal action from progressive builders, and that includes being sued for damages, including interest, maintenance, and holding costs. That's on the house itself. Legal action requesting specific performance, meaning that the progressive builder company could force the Singh family to take possession of the house even if they tried to walk away from the contract, and that's adding on top of the damages that come from not being able to sell the house when they were expecting to, and legal damages in terms of alternative dispute resolution costs, potentially court costs, anything like that, which may exceed what the cost of just taking the house would be. In terms of the $27,000 paid to Helmut in exchange for on-time delivery of the house, which they never received, we can establish a very strong case for fraudulent misrepresentation, which is reliant on the fact that the information given to the Singh family by Helmut was knowingly misleading, stated without belief in the truth of the statement, and recklessly without caring about the truth of the statement. And we can establish that all of these were there because Helmut fled with the $27,000 after it was paid to him. The Singhs suffered damages as a result of the fraudulent misrepresentation committed by Helmut, both in terms of the cash payment, the $27,000, and because they now have no home to live in because it was not completed as they were promised it was going to be. One argument that progressive builders would likely make is that when Helmut contacted the Singh family and promised them on-time construction in exchange for $27,000 payable to him, that he was acting as his own person and was not a representative of the company. The problem with this argument and why it would likely fail in a court is that Helmut, in the reality of the situation, was an agent of the company, at least at one point, because he was the only salesperson the Singh family had dealt with. He was a legal agent representing the company, and he gave the impression of agency between himself and progressive builders. And if he was not acting as an agent anymore because he was fired or whatever the conditions may be, it is required for the company to notify the clients that this person is no longer an agent in our employ. Helmut's fraudulent actions are directly related to his employment as well, and so it's not like if Helmut were to rob a bank, progressive builders would not be liable for that because the crime committed by Helmut is completely separate from his employment with the company. In this case, the tort is completely related to the company. In fact, it's reliant on the fact that the Singh family depended on Helmut as an agent of progressive builders. And so, since it's related and they were not notified, the Singh family is likely entitled to remedies. Since Helmut was an agent of the company at one point and gave the impression of agency when he defrauded the family for $27,000, progressive builders, as his employer, at least at that time, are vicariously liable for the torts committed by Helmut. Even though they did not benefit from it, they did not get the $27,000 that he fled with, they are still in part responsible for the fact that it was allowed to occur. When it comes to remediation for the fraud committed by Helmut in his employ with progressive builders, the remedies that would most likely take place here are specific damages for the $27,000 paid because this amount is fixed. We know exactly how much it was, but there's also general damages because we don't know exactly how much it has cost for the family to have to deal with not having a house that was delivered on time. And it's possible that a court would find punitive damages to be appropriate in this situation because fraudulent misrepresentation is one of the intentional torts, and as a result, it's possible that the company could be fined by the court because of Helmut's actions. In terms of what the Singh family should do from this point going forward, firstly, they want to put an effort into reasonably minimizing further damages. This means that even though you may not have a house, don't go stay in a 5-star resort and then later expect them to pay you back for it. Stay in a regular priced motel, something like that. Don't walk away from the contract because you have a very strong position here, and attempting to repudiate the contract just by walking away from it would give up a lot of the leverage that you have on that front. And then sue for specific damages, the $27,000 you were defrauded from, and general damages in terms of the previously discussed cost incurred from not having the contract completed correctly, as well as the costs of having the wrong house model constructed, because it's very possible you could get damages returned from the company for not having a den, among other things that you might have to upgrade post conclusion of this case. We're Group 2, and this was our analysis of the Singh family versus progressive builders. If you have any questions about it, just email any of our group members. We would be happy to answer them, and thank you for watching.